Welcome to The Exchange. I'm Faisal Karmali, and we've got a great interview. For those of you who've been tracking all the COVID cases, all the problems happening in the hospitals and ICUs, we're seeing a big uptick in this country in Canada, and there are more and more concerns for business owners on a whole bunch of topics. One of those topics is what happens when it comes to layoffs, rehiring, all the concerns about opening and closing again. Because, right, to be honest with you, I don't think we've got a good handle on how this whole thing works. There is no system or process. Every single province is doing their own thing. And so when it comes to these types of issues, as a business owner, knowing when to lay off, when to rehire, more importantly, what are the laws behind all this stuff? We got to get the experts on board. And we've got two members from Osuji Smith Law Firm. We've got Charles Osuji and Amanda Ovaici, reoccurring guests to the exchange. Charles, Amanda, thank you for joining me.
Thank you, Faisal.
Okay, so this is the interesting part now. So Charles, I'm going to start with you. I think people are thinking about, we've opened up a bit. Let's talk about some of these retail and office spaces, maybe even in some restaurants. They've hired people back on. Things are going well. The provincial government comes out and says, okay, we're going back to limited capacity. In other provinces, they've actually even gone to curbside and delivery service only. And that requires potentially more layoffs. If what happens in other provinces comes to Alberta and we have to shut down, there's going to be some sort of layoffs. And where I'm confused on what's the difference between like a temporary layoff or an actual permanent layoff. Maybe we can start there so we can get some foundation on this conversation.
Excellent. So the difference is really on the permanence of the decision, right? If it's a layoff, then it's temporary. Temporary layoff suggests that this is not going to happen forever. The Employment Standards Code has provided for the time limit for the layoffs to happen. Under the code, the temporary layoff must be temporary, and the employer cannot lay off his employee for more than 60 days within a 120-day period. If a temporary layoff lasts longer than 60 days within a 130 days period, the layoff is deemed to be a termination of employment. So that is a temporary layoff. Unfortunately, people interchange layoff with a termination. They are two different things. A layoff is temporary, as I just stated, while a termination is permanent. If an employer terminates an employee, that means the employee's relationship with the employee has come to an end, and that triggers severance obligations, termination notice, termination pay, and certain other entitlements the employee deserves. But if it's a temporary layoff, then there is an indication that it's only going to last for a very short period of time. And if it goes beyond the stipulated number of days according to the code, then the employee would deem the temporary layoff to be a permanent termination and ask for a termination pay.
So just to get clarity on what you were saying here, Charles, if it's less than 130 days, so the minute you lay off somebody, there is a time limit to that. If I heard correctly, 130 days?
120.
120. So there's 120 days. If you foresee that you're not going to be back up and running or need that employee longer than 120 days, it's pretty much a termination?
Yes, it is.
And therefore severances and a whole bunch of other stuff get involved in that case. So what happens if we do a layoff and then we open up again and then we close again, or we do a layoff for now because we don't know what's going to happen in 120 days, but it ends up being longer than 120 days? What happens in that situation?
Well, the reality is the general principle, a layoff is actually a termination, right? Under common law. A layoff means an employer is telling the employee, I don't have work for you, I'm not going to pay you. And those are basic covenants or promises an employer has made to the employee. So it's actually up to the employee to consider a layoff a dismissal or temporary. But that aside, if a layoff is going to exceed the minimum prescribed or the maximum prescribed under the Employment Standards Code, at that point, the employer should be ready to be terminating the employee, because if the employee goes to a lawyer or goes to court, the court is going to say that this layoff has extended beyond the requirements under the Employment Standards Code. Therefore, the employee is entitled to termination pay.
Amanda, I was thinking about all the different issues that come up during this pandemic when it comes to layoffs. When I report the news, I talk about the number of people that have lost jobs, either because of a layoff or because it's a permanent loss. What I don't get to report is how many people have been laid off and some of the common issues that we find from a business owner's perspective. So, from your viewpoint, what are the common issues that we're seeing around layoffs during this whole pandemic?
Well, I was going to say COVID has changed and it continues to change a lot of the ways that businesses more or less approach this, as well as the impact that it's obviously having on employees. Many businesses have been ordered to cease operations, while others are suffering from a drastic decrease in their revenues. I mean, including one of my own businesses. We had to force shut down and obviously can't even operate anymore. So you're not allowed to open your doors or allowed in-house dining, right? So there's also been layoffs across the country from small businesses to multinational corporations, and obviously you need to also take into consideration the bandwidth of a multi-corporation layoff versus small business. Multi-corporation layoffs have in-house counsel, so they're slightly more and better equipped versus smaller businesses are struggling in order to navigate. And I emphasize quite heavily that there's a ton of resources right now that are trying to be developed by law firms, by even yourself in order to better equip these small businesses to approach these situations. Some of the things that I'm prevalently seeing, and Charles and I are seeing prevalently in, especially as it pertains to employment law, are things like layoffs are occurring, but I don't think people realize that you can't do a layoff if your contract with or agreement with your employee when you onboarded them doesn't include a clause. So that's starting to cause severe issues in regards to the current existing um, atmosphere right now within employment law, and it's definitely accelerated the level of lawsuits that are coming out. There's also things as in, like you had mentioned previously with Charles, extending the time frame, not intentionally, but it's just because the businesses physically can't open up right now. So ha they don't want to even terminate their teams of employees. They've had great employees for the last 5 to 10 years, but they physically aren't permitted to open their doors. So we're able to, depending on the relationship between the employer and employee, sit down with both parties and communicate that if there's been a lack of communication between the two, and extend some types of payments for the employee for them to remain able to provide for their family, but also not hinder the business from going bankrupt. So this has been an unparalleled or unknown situation that if you have a good communication, I find with your employment team, you're able to extend and survive it versus getting bogged down with demand letters and lawsuits that are coming within the employment sphere.
So if I understood correctly, Amanda, are you saying that many contracts out there for employment do not have a clause about layoffs? And do you have to have one in the contract?
No? Yes. Yeah. Before you're allowed to even lay off any of your employees, your contract needs to be dictate that that is an option within your agreement.
So what happens if you don't have that in your contract? And I'm assuming, big assumption here, many business owners didn't put a layoff clause in their job letter or their contract for employment. So what do they do at that point? So they're laying somebody off, or do they just terminate them and say you're done? And like that's this big disruption, I'm thinking. So what happens in those scenarios?
So I'm going to defer to Charles to further elaborate on the multiple consequences, but you're right, it definitely has caused. This is why I would say every law firm in the city, employment cases have skyrocketed. To the point where people are allocating and restructuring their law firm from their civil litigation department to their employment because there's been a drastic influx Charles has I'm pretty sure a lot of people know, but he's got vast experience within the employment sphere. He's recognized in the legal industry for that. So, Charles, I'll let you utilize your years of experience and
Absolutely. Thank
explaining.
you. Yeah, so as I was saying, Faisal, generally, the general principle is a layoff is a termination. And the reason why it's a termination is because the employer is telling the employee, I don't have work for you, I can pay you. But there are exceptions, right? Number one, if the employer has an employment agreement with the employee where a layoff is justified, where there's a clause that says, under given circumstances, the employee could be laid off for a certain period of time, then that employer has a contractual justification for laying off the employee. This happens more often in the unionized environment where collective agreements typically would have a layoff clause. In the private sector as well, many employers are encouraged to have it. But unfortunately, as you recognize, Faisal, if there are 100 contracts out there, only 4 would have a layoff clause, before COVID. But COVID has reawakened a lot of consciousness, and people are now redrafting their contracts to make sure there's a layoff clause in the contract. However, if the employee, even if the employment contract does not have a layoff clause, if the employee agrees with the layoff, then the layoff becomes legitimate and becomes justified, so long as the employer is recalling the employee within the time period allowed under the law, which is 120 days given COVID. If the employee refuses the layoff, then the employee has the option of pursuing a termination or constructive dismissal case against the employer, right? So in other climes like BC and Ontario, the position of the law on layoff is very clear, that if the contract does not provide for it, it is constructive dismissal unless the employee agrees to be laid off. In Alberta, there's been conflicting jurisprudence on it. One case says the layoff is termination. The other case says the layoff is a right the employer has with or without an employment contract. But the general consensus is without an employment agreement justifying a layoff, the employee that has been laid off has the right to go to court and seek termination entitlements against the employer.
Okay, so let's think about from a business owner's perspective. Let's think preempting all these issues, because we don't know what's going to happen if there's this third wave gets worse, if there's a fourth wave coming out, hint, hint, nudge, nudge, all these different things that are going to be potentially coming out. Can a employer today amend their contract with their employees to now input that layoff clause, and as long as the employee signs off on it, can they do that?
Good question. Before I answer that question, Faisal, I wanted to add one more exception. Remember, I've identified two exceptions, which are if the contract provides for layoff. Secondly, if the employee agrees to the layoff. The third exception is where, due to reasons or factors beyond the business owner's control, a layoff is necessitated. For instance, a government shutdown, right? Amanda has indicated her restaurant, Alchemist, has been shut down because the government has said there's no in dining anymore, or unless you have a patio. In that situation, Amanda or her restaurant could get away with laying off staff because of that government shutdown, because that is a factor beyond the control of the business owner. But if there is no government shutdown, if there is no municipal or provincial directive for a shutdown, but the business is simply losing revenue and the business decides to lay off, that is where the business has to be justified. The decision has to be justified under contract, or the employee has to agree. But back to your question, yes, an employer can make changes to the contract to now add a clause that was not in place before, provided that, number one, the employee agrees to that change, and number two, there is something new, or there's a benefit coming from the employer to the employee in exchange for agreeing to that. Many employers go with a signing bonus, give the employee $1,000, $2,000, $500, because the employer is suddenly taking something away from the employee. Before the contract, the employee had the right to say no to a layoff. And the employer now wants to remove that veto right from the employee. And for that reason, something has to come from the employer in exchange for the employee agreeing to that amendment. They call that consideration in law. So long as the employer is giving the employee consideration and the employee is agreeing to accept the consideration and agree to the changes, those changes would now be binding on the employee going forward.
Okay, so
And
let me
sorry, I
recap
did
that
want to
because
just jump in. Oh, go ahead.
go ahead, no, go ahead, Amanda,
I
jump
wanted
in.
to just quickly jump in because I noticed actually I recently had an employee reach out to me in regards to amending their contract, and they didn't understand why they were suddenly being receiving $500 for an agreement to change a clause in a contract. So they deferred really quickly to me to make the inquiry. So for employees, that's something that I think we should really narrow in on is when you're suddenly out of the blue, your employer is coming to you with a $500 check and a contract saying specific words as this is in consideration. Consideration is that terminology that's indicating that you're receiving something in exchange for amendment happening to your contract. So I want to narrow in that scope because this is actually happening quite frequently and with no explanation to the employees. I'm just receiving this cash and I'm excited to accept it, but I don't know why. Review your contract because there's being a change with your employer and the employee relationship that you need to really be aware of. And it's happening quite rapidly now because of the changes and the impact of COVID.
So let me just try to recap what I just learned today this last piece here. Um, in the event that there is a government shutdown, it's government mandated, and businesses like Amanda's, for example, her cafe does not have an outdoor patio. She has to shut down, um, so she can go ahead and lay off people because it's been government mandated. Can I get a yes or a no on that one? Yes. Okay, good. Okay, so I got that part figured out. When we amend a contract, and Amanda, you're saying that people are coming in to their employees and saying, "Here's an amended contract. Here's a signing bonus." They'd be very careful of what's in the contract, how it's written, and what's the benefit for the employee. And the employee can always say no. Correct? Yeah. Okay.
Yes, the employee, if you're receiving that, and they're not saying that there's an amendment to the contract. They're usually saying, here's a bonus, and we're just, here's our new employment contracts that all new employees need to sign. First of all, you don't need to sign it. Second of all, take the time, review this contract, and compare it to your contract because there are instrumental changes occurring. And the reason they're providing you with that additional income or bonus per se is because they need to compensate you for whatever amendments are currently happening in your current existing contracts, in your current existing or new contract. So make sure you're taking the time to review that because you don't want to be relinquishing any of your rights that differs from your previous agreement that you're not agreeable to. So people excitingly take the cash without realizing what their rights are being tied to all of a sudden. And you don't need to accept it. You can defer and say, I want our agreement to be in compliance with the original existing contract, and I don't want the bonus.
Okay.
Can I add a few more things to what Amanda said? Okay.
Sure. Go ahead, Charles.
Absolutely. Oftentimes, when the employer all of a sudden gives the employee a new contract, that is, um, the employee must review the contract with a lawyer. I can tell you that the difference between what the employee would have before the amendment and what the employee would have after the amendment is night and day, to be very honest with you. In as much as you're getting $500, $1,000, you're actually walking away from at least maybe $10, $15, $20,000 just because of $500, because of $1,000. And secondly, it's no defense that you did not read the contract because believe me, there's a clause in that contract that says that you read it. And there's a clause in that contract that says that you come to a lawyer to read it. And there's a clause in that contract that says you understood the terms and you agree with the terms. So willful blindness is never a defense.
But this is an interesting thing you're saying, Charles, because you're giving the employee's perspective. I like to take the employer's perspective now. And there is a way that you can handle yourself in an amendment of a contract. I don't want to come across saying employers are being sneaky and kind of putting a $500 bill in an envelope and kind of sliding it over and saying, here you go, and just sign the contract. There needs to be some sort of approach to this that's above ground, ethical, moral, legal. What would you suggest, Charles, that individual business owners should do to keep everything above ground when they need to amend it to protect the business, but also to let the employee know that there is a change and what's the rationale behind that change?
Absolutely. So number one is ensure that the employee is given a copy of the new contract. Give the employee at least a week. I've seen employers give employee a melting ice deadline. Get back to me before tomorrow morning. Get back to me before noon tomorrow. Give them at least a week and offer to pay their legal fees reviewing it. Give them additional $500. Go talk to a lawyer. I want you to understand what you're signing, right? And make sure that the clauses that really impact on the employee's right, that is a portion in under those clauses where the employee initials, that they've specifically read those clauses and they understand the impact those clauses have on their legal rights. Have them initial those clauses, not just the general signature at the last page. Once you do all of that, as an employer, you have done all you can. Believe me, you could give someone $3,000 to go find a lawyer to review the contract, and they just put it in their pocket, and they return the contract to you the following day. But so long as you check all those boxes, you get away with any changes that the contract portends down the road.
Also, and I don't mind jumping in on this. You don't need as a business owner to, I feel like sometimes business owners believe that they need to urgently get these matters done in order to protect their businesses. And I think that usually what happens between employment issues and employee and employer issues is there's a lack of transparency and honesty sometimes that's occurring. I feel like majority of the employment issues that we're seeing that's coming across our desk could have been easily avoidable if they just were being transparent, honest with their employees, and fair. I'd say fair. I mean, when COVID hit at our business, I sat down with each and individual employee. If I was requesting them to sign a new contract in order to meet the change of everything that COVID has impacted, I would have sat down and said, this is our new contract, and these are the elements of why I'm having you sign this new contract, and this is why. And this is why we need to, as a business, to do so in order to remain financially responsible so that we survive this COVID. And we are hoping that you're in agreement with it, and if not, we're willing to offer fair compensation. And if you are, we're also willing to offer fair consideration for you in agreements to changing our employee-employee relationship with this new agreement. If you came to your employees with such a humane, I think, approach, and you literally pointed out the new clauses within the contract that you're trying to amend, instead of just giving them the contract and telling them good luck and you have 24 hours to read it, I think 90% of the issues that we're seeing could have been prevented, to be honest.
So this is a way of actually taking a step back, business owners, thinking about what you want to do and change for your business, educating and informing your employees, doing everything within a reasonable amount of time. And Charles was talking about a week is a good amount of time. Even encourage them to go get independent legal advice, make sure that they're comfortable with it. That just puts everything out of the problems in the future and puts it in the present and saying, here's where we are. Can we work together on this? Because we want to make sure we can get through this pandemic. So, Amanda, thank you for that. Charles, I want to come back to you in regards to one question that I've been hearing from your firm, other lawyers and your counterparts in other firms, they're saying to me it is getting busy as crazy as hell with all the calls that are coming in, all the employees and employers wondering what they got to do and how do they got to do it. So this is good. I like the fact that at least they're reaching out and getting advice. What ends up happening, and I think this will happen in the near term, call it 6-12 months out, there's going to be some fighting going on between employer and employee. And that will then bring a lot of people to the legal world. Are there other programs besides individual lawyers? Can they come into a mediation to figure this out? Is there some sort of program that's set up in Alberta where individuals, employer and employee, get together in front of somebody to kind of handle these disputes quickly, efficiently, without large cost to the overall pocketbook for these individuals?
That's a very good question. Um, you know, I think Amanda kind of highlighted the failure in transparency, and I can tell you that that has been the one thing that repeats itself in my consultations. I do at least 6-7 consultations a day on these issues. Right? Is the amendment, the agreement saying one thing, and then the person communicating the agreement saying the other thing. I have a woman. I had a client that in her 60s. The changes to our contract were quite invasive, but the enclosing email that sent, the email with which the contract was communicated to her said, please note that there are no changes to your contract. Just sign the enclose and return to us. Anyhow, the reality is COVID-19 has amplified some of these issues, and we're now we're experiencing a lot of traffic. Employees trying to understand what their rights are, employers trying to understand what their rights are. Unfortunately, this is happening after the fact. Many people think that lawyers are like doctors, only go to a doctor when you're sick. Go to lawyers before the problem happens and prevent it, instead of going to a lawyer when the problem has arisen. So here we are with a high volume of work coming in, and the judicial system is unfortunately slow, right? An employee files a claim today, the employee can only go before a judge in a year and a half. How crazy is that? And this is someone that has lost their employment, has lost their source of income, and is looking for some compensation, but then they have to either pay a lawyer for another year and a half to get before a judge, or pivot and find something survival to do. So that is the reality of the judicial system. So what we try to do is to encourage the management lawyers to explore negotiation. The very first month we take on a file, we are hammering out demand letters. We're trying to resolve, before we even go to court, we're trying to make a case for the other side that pursuing this matter might not be feasible, because there is only going to be one winner at the end of the day. That winner is a lawyer, unfortunately. So the reality is, get an early resolution of the matter. The unfortunate thing, though, Faisal, is we do not have. It's not mandatory to explore negotiation between two parties. Negotiation is completely voluntary. So you have to have a willing employer and a willing employee to explore negotiation, which is something that I think should be reconsidered. If both parties are mandated to explore negotiation within a month or two of commencing litigation, many of these cases would resolve at mediation. Because what tends to happen is you have a lawyer that is quite gung-ho in going to court, instead of exploring litigation and helping their client get an early resolution. And the client's voices is not. Many of these people, they talk to lawyers. Many clients talk to lawyers once or twice in their lifetime. And when they get into this system, they don't know what to expect. They don't know what to do. They don't even know that negotiation is an option. They think everything must go to court. And then, unfortunately, have some lawyers that are very litigious. They rather fight as long as possible. So we're missing that in the system where negotiation is mandated at the very early stage of the process. We're also missing, getting more judges on the bench, right? So that we can have an earlier court date, instead of having to wait another year and a half or 2 years before we get to court. Hopefully, with COVID-19 and the impact it's had on employment and litigation and disputes, hopefully, we could see some changes that are positive.
That's very interesting for you business owners out there, that it's not only a change the contract, get it over with and move on. There's a lot of risk on the table there. Like Amanda was saying, make sure that you are above board. She used the word humane. I think that's a very good word to use in these times. It is very, very stressful for everybody involved. So give people time, encourage them to get their own ducks in a row, get their own advice. All those things are important in times like this. And you heard Charles say the time between when the first letter gets sent out to when you possibly could be in court could be years. And do you really want to have that headache for that long of a period when all it took was a bit more humane way of dealing with it? And unfortunately, the negative stigma in our society will be against the business owner. It won't be against the employee, right? Very rarely do we hear about a bad employee who screwed over a business owner. We normally hear business owner screwed over employee. So understand the environment that we are in. And of course, we've got two fantastic lawyers. They are busy, but they are willing to work with you in your situation, with your business, but they want to give you a bit more of an understanding. This is not to let's take your case and let's go right to court and we'll fight it all the way to the top. That's not their style. And that's why they're on this show, because they're here to help. Now, Amanda, I'd like to come to you first on this one. We'd like to wrap up here. Whenever we wrap up on the exchange, we want to give 2 or 3 pieces of advice you would give business owners today when it comes to dealing with this issue that I think is going to happen more and more when it comes to layoffs, communication with your employees, and having that humane approach. What are your top 2 or 3 things you would recommend or give advice to business owners today?
So I would say, first off, you made a good point that in your conclusion just now, that there is, you always hear about the bad employer, but you never hear about the bad employee. There is a presumption within the legal industry of the imbalance of bargaining power from the employer versus the employee. And that is why there is that kind of more or less forethought or approach in regards to how lenient and how open-minded the employer was when they were and transparent the employer was when they were onboarding that employee. So I think in regards to right now the current climate, there's a few things that employers should be doing, and that is, before you do a layoff, I know things are happening quite rapidly, so you don't have as much time period, but I'd say watch the news, keep track of if numbers are rising and you anticipate that you might be needing to do another layoff. Reach out to a lawyer and find out what the current existing climate is, in order to better navigate the waters, and how to approach the situation in the best way possible based on your current agreements that you have in place in order to do a proper and fair layoff. Now, during the process of your layoff and after times have been progressing and you still can't bring those employees back, then reapproach that lawyer again and get them to review the current circumstances and climate as per the environment of your current existing business, to what's the best way that I approach this in order to ensure that my employees feel like they've been treated fairly, that my employees are getting fair compensation, and to avoid any legal issues. Make sure that, and if there is an issue that's escalating, get ahead of it right away. Contact the employee or secure counsel or mediation with a lawyer in order to sit down and say, hey, listen, these are your legal rights. This is my legal rights. This is the current existing situation we're in. How do we come together in order to effectively resolve it? If an employer treats an employee with that level of respect, I find employees are not out to hurt their employer or hurt their business. there's viability in seeing the success of businesses continuing after COVID. But if you mistreat your employee and there's hurt feelings there, then that's when animosity and these things arise and move forward to court. So once again, transparency, humane, but get ahead of it before you do any layoffs. Get ahead of it during the layoff process. And it's not hard to do. I mean, an hour consult with a lawyer will probably suffice, unless the issue becomes more complex. But being humane, transparent, fair, and getting ahead of the issues is what's really going to prevent you from going to court.
I think this is a key thing that we have to really remember, business owners. Amanda just gave one of the biggest pieces of advice that you will hear from this time is get ahead of it. Don't assume you know what's the right thing to do in this situation. This is a pandemic and we haven't lived through this type of stuff. And Charles was saying earlier, there's a huge magnifying glass on what's happening right now. Everything's going to come out. So let's make sure as business owners, we get ahead of it. Amanda also said, 1 hour with a lawyer, yeah, you have to cut a check to pay for that time because you're getting the knowledge and wisdom of that legal professional. But on the flip side, it could save thousands of months, thousands of dollars of damages for that 1 hour just to get ahead of it. So please, 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 we're going through another wave. I believe there'll be a fourth wave if that does hit. And if we go to this accordion economy, closing and opening, your business may be impacted. And what we don't know is what's on the other side of that is 1 to 2 years out, like Charles was saying, you could be sitting in front of a judge and here you are now, thousands of dollars in, all to prevent just 1 hour with some legal advice. Amanda, I really, really like that piece of advice. Charles, you guys are busy. You got a full team. Your whole firm is working on this. I want these individuals who are watching this to get in touch with you when they get that 1 hour consult, at least that 1 hour consult. How do they get a hold of you?
Well, our website is www.osugismith.ca. Our phone number is 403-283-8018. And just to punctuate what Amanda has brilliantly articulated, at the end of the day, employment is like a third. Employment defines a lot of people, right? People spend more than a third of their lives at work. In fact, many people are defined by what they do, right? And that triggers the need for humanity in that relationship. Many employers get carried away. I understand you're the one cutting the check, you're paying the payroll, you're paying the employees, but at the end of the day, it's a contractual relationship. It's not the master servant relationship we used to have. It's a contractual relationship, and there's an imbalance of power that tends to favor the employer. Because of that, the employer has to be very, very careful. 98% of the people that come to us came to us not because of what was done to them, but because of how what was done to them was done to them. That's what I hear all the time. It's not that they were terminated. When you start an employment, termination is a possibility. But the termination is not the issue. It's how they were terminated. They start saying things like how they brought so much value to the company and they showed up at work. There was no prior notice. They were blindsided. And they also say something about the HR was telling them how their performance was an issue, and they never heard about that issue prior to the termination. They heard it for the first time at the time of termination, and that was the basis for the termination. It's all about how or the manner of the dismissal. This is what pushes people to the hands of lawyers. Nobody wants to go pay a lawyer $400, $500 an hour, only when they feel that they've been treated so badly. So bringing humanity into the relationship, transparency, and as Amanda said, get ahead by, and you said as well, Faisal, get ahead by having a chat with a lawyer. Don't be a Google lawyer. Don't go to Google and read all those materials and you think that you know it all. There's a reason why people like us, are doing what we're doing. Thank you.
Yeah, and so for those of you part of the Entrepreneurs Growth community, those of you watching this one segment right now, I will make myself available. You send your contact information to me, and I will connect you with Amanda or Charles directly, because I think this is very important. Take the time out for this. This can be devastating not only to your employees, but to your reputation, your brand, future employees coming to you, individuals who are going to get, I guess, references of other employees who work. Can be rippling effects over years, because it's very easy to destroy a brand, a reputation, by just screwing up a relationship with one employee. So as we go through this pandemic, that 1 hour conversation with experts like what we have in front of you right now, I will take the time out to chat with you, connect you with Amanda and Charles, so that you guys can get the best, most up-to-date legal information and the advice to handle your business the way it should be handled and not have to go through the problems. Amanda, Charles, I want to thank you so much for taking the time out, recording this with me, because I think it's a very important topic. And part of what you both have done is educated me so much in this part of the world. I don't spend too much time worrying about the legal side from employer to employee, but you've opened up my eyes on a lot of issues in this and all of our other conversations. So I'm going to take a personal effort to let anybody know that if they need help, I will direct them your way, because I think it's very important. I want to thank again both of you, Amanda Ovaici, Charles Osuji, joining us today on The Exchange. Have a good day.